Hi, Sarah Jacobs here. And today we're going to talk about a hot topic in divorce, and that's money. Specifically, we're going to talk about marital debt and how, if you owe money to third parties, how those liabilities can be divided between you and your soon to be ex spouse. As you may anticipate, this is one of those hot button issues for divorcing couples. But it's important to remember that New Jersey is an equitable distribution state, which means that assets and liabilities are distributed as it means equitably, which is not necessarily equally. So, what does that mean for you and your soon to be ex? First, let's define debt. Debt can be anything from a mortgage, 401k loan, bank loan, car financing loan, to monies that you might owe to the government or to a third party. Second, let's talk about whether that debt is premarital or marital, and whether you can define it as separate. Traditionally, marital debt is considered something that was accrued or accumulated during the course of the marriage or was used for the marital enterprise or the family's benefit. It doesn't matter whether it's in your name or the name of your soon-to-be ex-spouse. If it was used for the marital enterprise, it may in fact be marital debt. Separate debt, however, belongs to either one of the parties, such as debt that was accrued prior to the party's marriage, or debt that was incurred during the course of the marriage, but may not have been for the family's benefit, such as secret gambling debt. One of the things that we often see from clients who come to our office is, does my ex-spouse have to share in my debt, or do I have to share in theirs? This is where a lot of people wind up fighting. This is especially true in cases of student loan debt when the loan was incurred during the course of the marriage, but maybe for something like a high degree that won't be utilized after the divorce. So, how does a court decide what's marital debt and how that debt is divided? The court looks at a number of circumstances, including the parties' overall incomes and earning capacities, whether there were any mid-marriage or premarital agreements, the parties' monetary and non-monetary contributions during the course of the marriage, as well as a variety of other factors. One of the most important factors we've already discussed, and that's timing. When was the debt incurred? And as a follow-up to that, how that debt was treated during the course of the marriage. Was it a premarital debt, but consolidated using marital funds and marital expenses were paid for during the course of the marriage? What about a mortgage? If there was a mortgage that existed on the property prior to the time of the marriage, but then the parties used marital income to pay the mortgage payments, is that marital debt or non-marital debt? These are all very fact-specific questions that a court has to look at when determining how to allocate responsibility for monies owed. Since these are all really specific questions of fact and maybe time-consuming, an effective and often used tool by divorcing couples to help itemize debt, define what's marital and what's separate, and talk about how to share their assets and liabilities is mediation. Mediation can be a customized, time-efficient, cost-effective way to answer these questions. And for your family, you can be very specific about payoffs and other factors that the court may not consider. Whether you're using mediation or you're going through the court system, defining marital versus separate debt and how to divide those liabilities, and of course your assets, can be scary. Having an experienced family lawyer who's done this all before and who knows the right questions to ask and the right documents to review can be pivotal. If you're divorcing or you're thinking about divorce and there are questions that you have about debt, we're here to help. We look forward to talking with you.